As a musician, protecting your original work is crucial. And today I want to help you learn a little bit about how to copyright a song. If you're a recording artist, songwriter, sound engineer, composer, or in any way involved in the creation of an original song recording, you know how important it is to protect your original work. Music copyright can help ensure that you have legal ownership and control over your musical work or sound recordings. In this video, I'm going to walk you through how to copyright your song and safeguarding your exclusive rights associated with that copyright. I want to start with talking about the basics of copyright law for musicians. Copyright protection exists for any original work of authorship, fixed in a tangible form. Now, trademark protection extends to brand names, logos, or anything associated with the brand that is a source identifier to the consumer. In comparison, copyright protection extends to creative and original works, which include original music. If you want to learn more about the difference between trademarks and copyrights, I have another video and a blog posted on my website at www.drishtilaw.com, or just go to my channel and search for the trademarks versus copyright video. Now first, as a musician, you need to create a record of your song. As a musician, once you have fixed your song, lyrics, or musical notes in either a physical or digital format, could be on paper or it could be on a hard drive, your work is safeguarded by US copyright law. An unregistered original work has what is known as the poor man's copyright protection, but copyright registration for a music recording has benefits when it comes to enforcement of your rights in federal court, including access to statutory damages, legal fees, and other damages. Now, before you register your song at the US Copyright Office, like I said, you need to create a tangible record. This can be in the form of sheet music, recording, or even just lyrics written down on paper. When you receive a copyright registration for your music, you will be afforded a bundle of rights that include the following: the right to reproduce the song, which could be in vinyl form, CDs, MP3s. The right to prepare derivative musical works based on the original song. That could be in sampling format, remixes, commercial use like for TV, ads, sporting events. The rights to distribute the work, which usually includes sellers or distributors' rights. The right to public performance, which usually includes digital streaming or venue performance. And the right to publicly display, which means publishing song lyrics, musical notes on the internet. Written or recorded music can be protected as a single song application, or multiple songs, like an album, can be protected as part of a music catalog. The US Copyright Office allows for a registration process where you can protect your original musical work or sound recordings. The work can be registered electronically or through a form with a small filing fee. Like I said, there are two categories of copyright protections for songs: musical works and sound recordings. Musical works, according to the US Copyright Office, is the underlying composition of the song, including sometimes the lyrics, and is often created by a songwriter or composer. This often includes the rhythm, harmony, melody, and notes associated with the song. This type of music copyright protects the performance of the work or song. A sound recording copyright is where a recording artist and other copyright holders, including producers, can register an audio recording incorporating a sequence of sounds and or words representing the original work. Under current copyright laws, a sound recording copyright owner does not have a public display right to public performance. These rights are only limited to performance of a recording through digital audio transmission, usually streaming services like Spotify or Apple Music. Therefore, an AM/FM radio does not need permission to play the song on their airwaves. In addition to getting your copyright music registered at the US Copyright Office, musicians in general should consider joining a performance rights organization, more often known as a PRO. So in addition to registering your song with the US Copyright Office, you may also want to consider joining a performance rights organization such as ASCAP, BMI, or the invitation-only CSAC. These organizations collect royalties, like mechanical royalties and others, on behalf of songwriters and publishers when their music is played on the radio, TV, or in public venues. By joining a PRO, you can ensure that you're being compensated for using your music and that your rights are protected. Now, protecting your copyrighted song goes above and beyond because you also have to protect your copyrighted song from infringement. Copyright infringement is one of the biggest threats to original work. A combination of copyright registration, monitoring, and enforcement policies with the assistance of an intellectual property lawyer will prevent the unauthorized use of copying of your original sound. However, even with the copyright registration in place, it is still possible for others to use your music without your permission. Copyright owners have many tools at hand to enforce their musical copyright. Exclusive recording contracts, performance contracts, online distribution agreements, licensing and publishing contracts, cease and desist letters, DMCA takedowns, the Copyright Claims Board at the US Copyright Office, and a copyright infringement lawsuit, to name a few. Can you copyright a song title as part of the copyright? Well, not really. Copyright protection extends to the original work that is minimally creative. Even short phrases usually don't count to be minimally creative enough to deserve copyright protection. Although musical works are considered creative enough to deserve copyright protection, one must look at trademark protection when considering protecting a song's name. A musical work always has a name. Smells Like Teen Spirit, Blurred Lines, and Back in Black are all terms that immediately identify the source or the rights holder of the musical work. Trademark protection extends to everything that can be considered a source identifier to a consumer. This is where a thoughtful IP protection strategy with the assistance of an intellectual property attorney can help. I hope I was able to give you a little bit of clarification on music and copyright laws. If you have any questions, need assistance with your intellectual property portfolio, please feel free to give me a call at 773-234-1139 or go to my website at www.drishtilaw.com and schedule an appointment. Can't wait to talk to you. As always, this is Sal Malhotra. Thanks for watching.